Dear learners and viewers, today we are going to discuss case laws on medical negligence, which is one of the services covered under the Consumer Protection Act 2019 as well as the 1986. Although medical negligence is not covered under the definition of service under both acts, however, the Supreme Court, based on the Supreme Court judgments on various cases about which we will be discussing about it, medical services and health services are covered in the Consumer Protection Act 2019. Now, the medical negligence may be divided into two categories. One is negligence by the doctors and the negligence by the hospital authorities and administration. Now, what is negligence? That is important to know. Negligence, that the failure to discharge the duty or to take the duty of care required to be taken by the doctor's concerned. Then, if the doctor failed to perform his duty or the breach of duty is concerned, then the causes in fact wrong. For example, with regard to duty of care, each and every doctor has a duty of care to be shown against the patient, not only about his health history, but other related aspects also. However, very often we come across cases where the doctors have found grossly negligent in discharging their duties to begin with, where I myself saw an occasion. I was witness to a case in a Safdarjung Hospital, New Delhi. It was an emergency case. I was accompanied with my own neighbor for emergency treatment. So the hospital asked the patient to stay for the overnight, and so I was with him. So during the course of around early 3 o'clock in the morning, I myself done another patient. He was for the heart patient, was brought in, and so at that time, whenever the heart patient comes with the heart problem, they should be the patient should be attended immediately and urgently. So what has happened? The night doctor was sleeping in some other room. So by the time the nurses sent the message and the doctor came, and there was very valuable time of 5 to 7 minutes are lost. With the result, the doctor as nurses failed to revive the patient. Ultimately, he died. I saw with my own eyes. When at times in emergency in emergency wards, the doctor should be not only available in the premises, but they should be available immediately for attending the patients. And in other cases about the negligence, gross negligence, very often several cases come to the court that wrong identification, there's no wrong, say surgery. In the case of surgery involved, wrong surgery, done against the actual parts to be the surgery to be carried out. For example, in the case of cataract for eye, instead of right eye, the left eye is cataract surgery has been done. These are the sheer negligence. Similarly, amputation cases, when the left leg, right leg is being amputated, like for several cases, then leaving the foreign body inside the body of the patient after the surgery procedure is over. Later on, it came to the knowledge that these are the time for a gross negligence of the doctor on the part of the doctor's concern. But I was giving a reference about the cataract surgery. In the cataract surgery, instead of one left eye, the right eye is done, or in the case of right, in the place of right eye, left eye is done. So wrong cataract surgery done on the patient is one of the sheer negligence on the part of the doctor. Similarly, for the case of amputation cases, wrong parts is amputated against the actual body, which parts was to be amputated. Then I also about the leaving the foreign part inside the body after the surgical procedure is over. These are the common cases come before the court of law. So these are the cases where the clear cut negligence on the part of doctors proved beyond doubt. Even the administration of wrong medicines, wrong diagnosis made by the doctors. These are the sheer examples of the medical negligence on the part of the doctor's concern. Let us take one or two examples of the negligence on the part of the hospital authorities. See, in the operation theatre, this filled oxygen cylinder should be made available. Now, in one case, what has happened? The doctor went to the hospital for surgery. presuming that the oxygen cylinder is filled with full of oxygen, then he kept that oxygen covered in the mouth of the patient, then started doing that surgery. Later it was found that the cylinder was completely empty. With the result, the patient died on the table of the operation, on the table itself. So it's you cannot expect the doctor to go and check the whether the oxygen cylinder is filled with oxygen or not. No, it is the sheer negligence on the part of the hospital administration authorities. Similarly, that a person has died, but when the family members waiting to receive the body, the dead body was handed to some stranger, third person can die. These are the sheer negligence on the part of the medical hospital authorities concerned. The doctor no role to play in this case and all. So this is what to conclude by saying that the medical negligence fall under two categories. One is the negligence on the part of the doctors who not only perform surgery, who prescribe medicine and do the diagnosis also, and other aspects are on the hospital authorities. Now let us come to some of the case laws on the Supreme Court, some of the important cases and all. Now the first case that come to the before the Supreme Court was Indian Medical Association versus V.P. Sharma in the year 1990. This is the first case wherein the medical negligence was came before the Supreme Court, wherein in this case only the Supreme Court held clearly and categorically that even though medical service was not covered under the definition of the Consumer Protection Act, but it is covered under the Consumer Protection Act. So from then onwards, this medical service is treated as a service covered under the Consumer Protection Act is concerned. Now, in this case, the court held that the services rendered by medical practitioners are covered under the Consumer Protection Act. The services rendered by doctors are not excluded under the exclusionary part, that is a contract of personal service. So in the definition of the service, contract of personal service is not covered under the definition of service. However, the court held in this case, even contract of personal service, that exclusion clause is not applicable to medical practitioners concerned. Then the next important point clarified by the Supreme Court was whether this medical service which covered service provided all are covered or any particular segment is covered. On this point, the Supreme Court held that whether it's a government or non-government doctors or hospitals or hospital rendering service free of charge to all patients are not covered under this service concern. Let me name it. Whether government, with regard to the hospitals, whether the doctor or the hospitals who are rendering free of service, free of charge, then in those cases that medical negligence is not covered under the Consumer Protection Act. Let us be understand very clear, whether government or non-government doctors, hospitals rendering service free of charge to all patients, that is very important. To all patients, then it is not covered under. However, if the hospital is providing free of charge to some percent of the patients and provide the services on payment basis to large number of patients, in such cases that doctors as well as hospitals are covered under the Consumer Protection Act. So to make it very clear, only wherever free charge of service provided free of charge to all the patients, they are not covered under the Consumer Protection Act. All others are covered under this case is concerned. Then contract of, I said already, the contract of personnel includes employment of a medical officer for rendering medical service to the employer is concerned. So this is what. Then next important case in the Supreme Court was Jacob Matthew versus State of Punjab. In this case, what is the Supreme Court ruled that a doctor accused of negligence or rashness may not be arrested in a routine manner. That means in the early 2000s and all, when the police used to go and whenever they get any complaint of any nature, they immediately rush to the doctor or the hospital, they immediately arrest them. But at the same time, one should understand, medical profession is a noble profession because they are doing service to the society. So, but even during the discharge of their duty, if there is some say negligence without their knowledge is crept into, then the police should not hurry up to arrest them and all, because they should not be arrested at all because they are doing a service. So here the Supreme Court in the Jacob Matthew case held that the police should not arrest them in a routine manner unless the arrest is necessary for further investigation or for collecting evidence as a simple lack of care. In other words, an error of judgment or an accident is not a proof of negligence on the part of the medical professional. See, sometimes the error of judgment, the doctor has to decide. I mean, you have to take a decision about under particular unit is concerned. Even I have known case of my own, that when the pregnancy test was carried out, in a patient, and the doctor was it was about a 50-50 case. The doctor said that there is the pregnancy is successful, but later on the family members later on learned that there was no the test was not positive. So then they started abusing the doctors. No, you said that the pregnancy test was successful, it was not the case and all. So in this is the error of judgment. No, margin of error of judgment is there for always, for all cases and all. Similarly, there is a error of judgment. I mean, it's a Supreme Court case. Maybe it's coming later. Okay, I will take that case at one. Then we will come to the other aspect of it. A simple lack of care, an error of judgment or an accident is not proof of negligence on the part of the medical professionals. So long as a doctor follows the practice acceptable to the medical profession of that day, he cannot be held liable for negligence merely because certain factors have been fulfilled, merely because a better alternative course or method of treatment was also available, or simply because a more skilled doctor would not have chosen to follow or resort to that practice or procedure which the accused doctor followed. No, here we cannot have the comparison between the doctor A would have done a better manner, doctor B would have done a better manner, or this doctor done a badly. No, we cannot make such a comparison and all, because each doctor, each person vary from his own way, from others. We are not same or similar to each and every thinking will different, their own capacity, skill, all will differ person to person. So therefore, simply you cannot say that as this instead of this doctor, the hospital has called the other person, why that would have, treatment would have been better. That type of argument will not be accepted by the court of law. Then when the charge of negligence arises out of failure to use some particular equipment, the charge would fall in if the equipment was not generally available at the particular time. That is the time of the incident at which it is suggested it should have been used. No, whenever they say that even the available equipments and all, if the particular equipment was not available in the hospital, about which the patients are complaining that if that particular equipment would have been used, the doctor would have been, the patient would have been saved. No, even if the facility is not available in the hospital, then we cannot blame the doctor or the hospital is concerned. Now, to continue other aspects also, to prosecute a medical professional for medical negligence under the criminal law, it must be shown that the accused did something or failed to do something which in the given facts and circumstances no medical professional in his ordinary sense and prudence would have done or failed to do so. This is what I said, in there is a saying, justice not only to be done, but it must appear to be have done also. Analogous to that, if the act done, if anybody, even the common man, come to the conclusion that the doctor would have behaved in a different manner, or the action of the doctor is a sheer negligence and all, then there is no answer for this and all. So the ordinary test of the common man is that ordinary test to be applied here. The hazard taken by the accused doctor should be of such a nature that the injury which resulted was most likely imminent. Like as I said, the late arrival of the doctor on this, whenever the patient is needed, his service, like the outpatient and all, it's a sheer case of negligence on the part of the doctor is concerned. Wrong diagnosis, as I said, also falls into this category is concerned. Now, Savita Garg was director National Art Institute. This is another case with this is the Supreme Court. In this case, the Supreme Court held that the burden to implead all those treating doctors or attending the staff of the hospital as party cannot be placed on the patient as to substantiate his claim. No, actually it's about the problem with the hospital administration. There was some negligence on the part of the doctors as well as the administration, but the hospital failed to give the name of the doctors who are involved in treating the patient's control. Then they were telling that the patient should tell the name of the doctor who was operating, who was attending to them and all. Then the Supreme Court that it is generally not possible for the patient to take note of the name of the doctors and all. No, it's not possible for the patient. Actually, the medical profession runs on faith only. So the patient, they keep faith on the doctors. They are at least bothered about the name of the doctors and all. But if certain extreme eventualities, if the patient has to file the case against the hospital and the doctors, then it is the duty of the hospital to provide the name of the doctors, nurses, and other authorities involved in the process of treating the patient is concerned. This is what the point held by this Supreme Court in the case of Savita Garg versus Director of National Art Institution. Now, the Supreme Court also in this case held that it is very difficult for the patient to give any detail about which doctor treated the patient and whether the doctor was negligent or the nurse staff was negligent. Quite natural. The patient only tell that the treatment provided or the cost was made by him was really no, it was unexpected. But he cannot determine and say this loss, damage or cost to him was by the negligence of the doctor or the nurses. That is, you cannot expect the patient to make such type of the decision or to come to the conclusions and all. The Supreme Court also observed that once an allegation is made that the patient was admitted in a particular hospital and evidence is produced to satisfy that the patient died because of the lack of proper care and negligence, then the burden lies on the hospital to justify that there was no negligence on the part of the treating doctor or the hospital. So once it is proved or proved by the patient that he or she was admitted in a particular hospital, that is sufficient for them. Then the negligence has to be the burden of proof to prove that there was no negligence on the part of the doctors and the hospital lies with the hospital authority. This is also decided in this case is concerned. Now, then the court also held that it is the duty of the hospital to certify that there was no lack of care of diligence on its part is concerned. Now we will move. There are several other cases. Now we will take another case. State of Unjust Shivaram. It's about this sterilization case. Family planning case. In this case, a woman has undergone the sterilization operation so as to avoid any future pregnancy. But unfortunately, for one reason or other, after she undergone the sterilization surgery, she became pregnant and delivered a child. Then the operating surgeon or his employer, in this case, the lady filed a case of negligence on the part of the doctor as well as hospital. Then in the Supreme Court held that the operating surgeon or his employer cannot be held liable in this case of this pregnancy even after undergoing the sterilization surgery. Cannot be held for compensation. Then they cannot be held liable compensation on account of unwanted pregnancy or unwanted child. The failure due to natural causes would not provide any ground for claim. See, actually there is no medical field. There is always 100% success. No one can assure you. 90%, 85%, 95% only. 100% success cannot be assured because there is a law of nature is also the act of God is there always. But even the doctors major case they say pray the God so that nothing is in our hand. The doctors openly admit that. So therefore, if such type of eventual like it happens, so you cannot. The doctor has done that sterilization to the best of her skill and capability. Beyond that, if then she became pregnant after surgery, we cannot blame the doctor or the hospital in this case. This was the decision given by the Supreme Court in the State of Unjust versus Shivaram. And the Supreme Court also elaborated this. The causes of failure can very well be attributed to the natural functional of the human body and not necessarily attributing to any failure on the part of the surgeon who performed the family planning operation. Merely because a woman having undergone a sterilization operation became pregnant and delivered a child, the operating surgeon or his employer cannot be held liable for compensation on account of unwanted pregnancy or child. This was the case decided in this case is concerned. Now we will come to another important case, PGI Medical Education Research, Chandigarh versus Jaspal Singh. This is the case about the wrong transfusion of the blood. It's a very ordinary, very sheer case of negligence case. In this case, wrong blood transfusion is an error which no hospital or the doctor exercising ordinary care would have made. Such an error is not an error of professional judgment, but it is a very nature of thing, a sure instance of medical negligence. So this is a clear case of medical negligence, utter negligence on the part of the doctor's concern. When a person is needing a particular O or O positive or A positive, only that particular blood alone should be injected into the body. If if they fail to give importance to the blood group, then there is no one can help the doctor or the hospital is concerned. The hospital's breach of duty is mismatched blood transfusion contribute to her death, and the most importantly, if such wrong transfusion of blood lead to the death, there is nothing sad beyond this. Therefore, it's a sheer negligence on the part of the doctor as well as the hospital concerned. So there they have to be provide record relief to the patient is concerned. Again, mismatched blood transfusion to a patient having sustained 50% burns by itself speaks of the negligence. Particularly when this burn cases are coming to the hospital, then they should be very extra careful and caution, because now they are already it's a very serious case. The death was caused by the breach of duty on the part of the hospital and its attendant staff. That has been confirmed in this case concerned. Now, in another case about the Jagdish versus State of AP, this talks about the Supreme Court again gone into details about that. When two conflicting opinions are expressed on the same subject matter, one in favor of the affected patient, that is the deceased patient, and another in favor of the doctor who treated the patient, which opinion should be taken into consideration? That was the issue in this case. Then in Supreme Court, in such cases, the question of determination of the which opinion should be taken, that should be left to the trial judge of the hearing the case. So they said that medical opinion may differ from person to person, but which opinion should be considered, that has been decided by the court only. The court trying the case of the medical negligence concern. This is the matter clarified in the case of Jagdish versus State of AP. The opinion of the Supreme Court was that the matter that required deeper consideration was that if from the first blood report a medical opinion other than diagnosis of the cancer was not possible, would this case still fall within the ambit of medical negligence? Therefore, two expert views in this regard were brought to the knowledge of the Supreme Court. However, which view ultimately would prevail was observed as to be a matter of the evidence. That is the decision given by the Supreme Court in this case is concerned. Now, we will move into another case where the Supreme Court has expressed its opinion is Martin F. D'Souza versus Mohammed Ishfaq. This is a 2009 case. In this case, the Supreme Court in this case indicated the broad guidelines to be followed whenever a complaint is received against a doctor or hospital from a consumer for a consumer forum or a criminal court alleging medical negligence. The Supreme Court further warned that the police official not to arrest doctors unless the facts clearly came within the parameters as laid in the Jacob case, which we have discussed already. The policemen themselves have no face to legal action only. So this is what the case concerned. Now we will take another case, Malaya Kumar Ganguly versus Shukumar Mukherjee. It's a 2000 case dismissed by Supreme Court. This is a very important case wherein the Supreme Court has laid down several guidelines. So guidelines have been framed by the Supreme Court with regard to the medical negligence. Number one is about on expert evidence. And with regard to expert evidence, the Supreme Court held that a court is not bound by the evidence of the experts, which is to a larger extent advisory in nature. So the court is not bound by the evidence as per the Indian Evidence Act. It is left to the experts. That's what one of the things. Then medical science is a difficult one. The court, for the purpose of arriving at a decision on the basis of the opinion of experts, must take into consideration difference between the expert witness and the ordinary witnesses. The opinion must be based on a person having skill, special skill or knowledge in the medical sciences concerned. Now, about the admissibility of medical evidence in criminal trial vis-a-vis proceedings before National Commission. This is about the opinion about the admissibility of evidence. The medical opinions are not admissible in evidence in criminal trial. The medical opinions are not admissible in evidence in the criminal trial. However, the same are admissible before the consumer fora. That is clarified by the Supreme Court. Then civil liability under civil law as well as the consumer protection law. The attributes of care and negligence are not similar under the civil law and the criminal law breach of the medical negligence concern. In the civil law, the liabilities are different. The criminal law, the breaches of the medical negligence is different, and the consumer fora it is different. So, depending upon this, the matter will be decided by the courts concerned. Then, right of the patient to be informed, very, very important. The patient has the right to be informed about not only the nature of the cure, but also the type of treatment to be given given to the patient concerned. Very often, even recently it appeared in the newspaper also, that doctor carried out the treatment without informing about the patient about the nature of the procedure to be performed. Ultimately, that matter has gone to the court and all. That is one thing. So, the point is, ordinarily the patients are to be informed about the admitted risk, whatever may be the nature of the disease, serious in nature or otherwise also. Generally, the patient to be informed about the admitted risk. However, if some medicine has some adverse effect or some reaction is anticipated, the patient should be informed about all. Even very of the doctor should inform. Suppose if the adverse effects are noticed, then it should be brought to the notice of the doctor concerned. Then, what is the individual liability of the doctor? That is also the court clarified that. Court, on the basis of the following facts shall be determined the medical negligence of the doctor is concerned. Number one, no guarantee is given by any doctor or surgeon that the patient would be cured. Number two, the doctor, however, must undertake a fair, reasonable and a competent degree of skill which may not be the highest skill is concerned. Now we can skip the Supreme Court finally held that concluded that the attending doctors of AMRI were negligent, but not to the extent of being guilty of commission of an offence under section 34A of the IPC. According to the Supreme Court, directed the AMRI Dr. Mukherjee to pay a cost of 5 lakhs, which ultimately came increased to 6.08 crores. It's a simple case of the 3 doctors have attended to the patient, and it's about the wrong diagnosis and wrong admission of the treatment that led to the death of the patient concerned, and 6.8 crore compensation awarded in this another case of this. Then Nizam Institute of Medical Science versus Dhankara, this is a case, and in this case Supreme Court observed that these observations do not justify an excision of biopsy, but equally support the case of complainant in as much that his case too was that had a MRI been performed, the extent of the tumor and its extension into that spiral cord would have been revealed. The Supreme Court held that complete investigations period to the actual operation has not been carried out in this case. Therefore, the doctors has to carry out the complete investigation before carrying out any surgery. That is what very, very important, clarify the court is concerned. Now, the occupational negligence is different from the professional negligence. The Supreme Court in this case clarified that. What is the difference between occupational negligence and the professional negligence? A simple lack of care or an error of judgment or an accident is not proof of negligence on the part of the medical professional. On the contrary, a professional may be held liable for negligence on one of the 2 findings. Either he was not possessed of the requisite skill which he professed to have possessed, or he did not exercise with reasonable competence in the given case the skill which he did possess. This is what then see the another thing, once the initial burden has been discharged by the complainant by making out a case of negligence on the part of the hospital or the doctor concerned, then the onus shift on the hospital or the attending doctors, and it is for the hospital to satisfy the court that there was no lack of care or negligence on the part of concerned. The hectic compensation awarded in this case. Then one more case is the CP Sri Kumar versus SP Ramanujam. In this case, the Supreme Court ruled that 3 issues taken by the Supreme Court for consideration: whether the doctor who gave the treatment had the competence to perform a homeotherapy and whether he has chosen this procedure as he was not qualified for the internal fixation procedure, whether Was there a negligence on the part of the doctor, hospital, ward boy and labor who were said to have taken the patient to the X-ray department, which aggravated the situation, necessitating a medical treatment? See, once the surgery is over, the patient has been taken to various departments, and while taking the patient to various departments, if some accident has occurred, the doctor cannot be held liable and responsible. Whether the homeoplasty was appropriate one in the light of the fact and the respondent was 40 years of age and the relevant time, the court held that the fact will determine the case and all. This is all very briefly of some of the cases and the rulings laid by the Supreme Court is concerned. For rest of the things, please refer to our the study material so that you can go get more information about it. With this, we thank you all of you for listening. This discussion is concerned. Thank you, please.